everybody. Thanks for coming to my talk on smart grids and subpoenas. So let me ask here, how many people here, if any, have a smart meter? 0. How many people come from states where smart meters are installed extensively? Anyone know? And the state would be? California? Georgia? Any other state? Texas. Okay, but you don't have one yourself. No, and you don't have one. New Jersey. Okay. Anyone here been subpoenaed? Had their data subpoenaed? Had their data be the subject of a warrant? No? Okay. All right, that gives me a good idea of everyone's personal involvement in this topic. So I'm going to talk about the vulnerabilities related to the smart grid and smart meters that tend to be far more extensive than most people are aware. So the vulnerabilities I'm talking about are the data and the extensive data that's collected by smart meters, and the threat is to civil liberties. And it's basically, I'm going to review the case law related to thermal imaging and energy usage, as well as CALEA and some of the other statutes that are used to subpoena the information. The threat is that I'm talking about today is from government surveillance. So there are a number of threats related to the smart grid, and this is just the one that I'm going to particularly focus on today since we have such a short time. And I'm going to talk about subpoenas and warrants, but also national security letters. Anyone here familiar with national security letters? This is a topic that's gotten a lot of attention lately from Chris Soghoian and other people studying privacy. And then talk a little bit about what's being done to mitigate the threat. And so the next question is, who am I? Who am I, anyway? And so briefly, I was formerly a senior vice president and senior executive at Putnam Investments, a subsidiary of Marsh & McLennan, in charge of disaster recovery and security, among other things, during their failover from the World Trade Center during 9/11. What's my connection to the smart grid? I sit on the NIST cybersecurity working group on the smart grid for privacy and security. I'm a PhD student right now in the College of Computing and Information Science at Northeastern University. I just finished my master's degree at Boston University in computer science, and I'm actually concurrently doing a second master's degree at Boston University. I don't know why. I don't know why I'm doing a PhD either, but it's a lot of fun. I have a preceptorship at Northeastern University Law School on cyber law, doing a clinic there. I have a certificate in private investigation. That's neither here nor there. And I also am a video producer at CCTV for full disclosure. Any other questions? Okay. So the vulnerability, those of you who come from states that have smart meters may have heard more about it. But smart grid information that's collected from everyone's private homes is a significant step up in information about what people are doing. And the aspects of it that are related to it are its granularity, the short intervals at which it's collected, the fact that it's real time or can be real time, that it's bidirectional because it allows people to sell excess energy as well as buying energy, and that it also includes location data because it's increasingly used for PEVs, electronic vehicles, which are becoming more, anyone have an electronic vehicle here? No? Think about getting one? No? Okay. So the question is how much closer it brings us to George Orwell's thinking about 1984, in which data about us is so well known that our every movement is practically known and trackable on a real-time basis. So this is actually a 3-year-old graphic that we used on the NIST Cybersecurity Working Group in our 2010 publication on security and privacy in the smart grid. So this is like very, very 3 years ago. But what it's intended to show is the granularity with which your energy data reveals the exact activities that you're doing in your house at your time. So in this one, we see when the fellow's opening the refrigerator, he then puts a kettle on the stove here and uses the toaster. These spikes are him using the washing machine. And then over here, he's using the kettle again. So that just gives an idea of what we're talking about in terms of the granularity of the information. Actually, your energy footprint reveals not only whether you're watching your television or what other appliances you're using, but it can reveal exactly what you're watching. every movie and television show has a unique energy footprint that can be traced through SmartGrid usage. Who is in your house, whether you're in your house, who you're with in your house, what you did minute by minute while you were in the house. All that information is very, very clear when you look at your energy footprint. So it's a significant increase in the amount of data. When you think about this kind of data, it kind of makes the days when people are concerned about their telecommunication information or their GPS location information, it makes that seem quaint, as if it were the good old days when that was the only information that was available about you. The source of that graphic, by the way, is a smart metering and privacy publication. So the background in case law related to energy usage data is the Kilo case. Anyone familiar with Kilo? It's a famous case of the that was mentioned yesterday by Spencer. Anyone come to Spencer's talk on the SmartGrid where he hacked a smart meter? There's a kind of an accompanying. Spencer McIntyre came in here yesterday and did a demonstration of hacking a smart meter, a real-time demonstration that I thought was fascinating, and mentioned Kilo. It's a case in which marijuana grower, a suspected marijuana grower, was arrested by the FBI. They got a warrant and used thermal imaging technology, sat outside his house at the curb in a police car, and were able to do thermal imaging readings. They then went and compared that to average usage and obtained arrest warrant on the basis of showing the differential between his average usage and the average usage of a person that doesn't grow marijuana, apparently. This case was overturned. It ultimately went to the Supreme Court and was overturned, and the Supreme Court ruled that you may not use thermal imaging, that it constituted an unlawful search and seizure, that the use of thermal imaging technology was a search. And it's a very famous case because it's one of the first cases in which new technology was used and was the privacy protections of the Fourth Amendment were fundamentally upheld. Since that time, the number of rulings that uphold the Fourth Amendment have become fewer and farther between. So CALEA is the statute. Anyone familiar with CALEA here? Communications and Law Enforcement Act. This is the law passed in 1994 in which telecommunications data was first widely subpoenaed. And it's used extensively today, far, far more extensively than it was originally envisioned in 1994. What's interesting about CALEA is that it was originally used principally for the war on drugs, and today, because of the breakdown of information that's publicly available through FOIA, we can see that it continues to be linked to subpoenas that are predominantly related to the war on drugs. And Chris Soghoian recently did some research, and I don't know if, does anyone here know Chris Soghoian? Anyone familiar with his work? He's the guy that published the fake boarding pass for Osama bin Laden, and the FBI raided his home and arrested him and confiscated his laptop. Anyway, he's just submitted his long-awaited doctoral dissertation last week, which is very interesting reading for people that like to read that sort of thing. And he talked about, he made a hypothesis that the war on drugs was selected to be pursued because it results in large amounts of cash that's confiscated by law enforcement from drug agents. And so in a way, it's a self-funding kind of a war. But anyway, that's just sort of a footnote. In 2004, CALEA was expanded substantially to cover voice over IP and broadband internet, which was specifically excluded in 1994. And between 2004 and 2007, there was a tremendous expansion in CALEA-based subpoenas that were issued. Any questions? No. Soghoian, in his dissertation, which he has titled In Spies We Trust, and which I quote here, notes that between AT&T and Verizon, Google, and Facebook, that he estimates that 1.5 million requests annually are being received from law enforcement agencies. What's interesting to consider is that this information is available under FOIA. What's not available is the information that's being requested by intelligence agencies, and there are a number of other means and channels of collecting information. So 1.5 million is just a fraction of the requests that are actually being made of these corporations. CALEA isn't the only means, though, by which information is being requested by major corporations like Google and Verizon. National security letters have become increasingly the avenue of choice for collecting information do not require probable cause, no judicial oversight, no reasonable cause, actually require nothing at all, and can now be signed by junior people in agencies. Did anyone just go to EFF's talk in which they talked a little bit about it? You were there too, yeah, you, of course, okay. EFF has done a huge amount of work in this area and are currently continuing to do a lot of work in this area. So national security letters are increasingly being talked about. They were actually started in 1978 to circumvent a law, the Right to Financial Privacy Act, and then they were significantly expanded in '86. On 9/11, there was another really significant expansion under the Patriot Act. In 2004, in Doe versus Ashcroft, they were found to be unconstitutional, which did not stop them in the least. Between 2003 and 2006, there were over 200,000 national security letters issued. And again, national security letters are simply letters that state that an agent feels that there may be a link to an ongoing investigation of many varieties. Don't actually require any evidence, don't have to go before a judge or really submit anything. Interestingly, in 2006 was the same year that the Department of Justice Inspector General issued their own audit and found that there was widespread abuse of the national security letters. So a few years after the expansion of the Patriot Act, the Department of Justice's own Inspector General said these letters are being completely misused on a widespread basis. There's no justification for them. When we look at them, we find they are not substantially linked to any legitimate investigation, which also has barely slowed down the use of NSL. In that year, 2006, there were 53,000 national security letters issued according to the government's disclosure. The next year, there were 16,000. So there was immediately a substantial drop, at least in what was reported. However, the numbers have since climbed right back up.
What are the NSLs used for?
They are used in lieu of a subpoena or a warrant or any type of judicial oversight or anything to compel corporations, mainly telecommunications companies, but also Google, Facebook, and other companies, to provide your personal information relating to your email, your phone calls, and anything else related to your communications.
So they're like a request for compliance that's not legal entity?
Exactly. So the Craigslist killer, who was working his wares in Boston in 2009, he was captured through data that was obtained using CALIA. So Boston law enforcement submitted got a subpoena from a judge, within 15 minutes of requesting it on an emergency basis, and captured his information in a close-by cell tower to the Westin Hotel. So that's an example of using a subpoena, with judicial oversight. The national security letters, the police or many agencies, FBI, all they do is write this national security letter, and they bypass even that minimal sort of judicial oversight.
If I'm like Verizon and I get an NSL, I can say no, can't I?
You could, and they're totally not saying no. So what's interesting to know about national security letters is that there have been two challenges to them. Out of 200,000 NSLs issued, there have been only two challenges. One was in 2006. It was resolved in 2010. And the interesting thing about NSLs is that they include gag orders, so the recipients are not allowed to reveal that they've received them. And in fact, they also appeared to prevent recipients from even discussing them with their lawyers, which was the subject of an ACLU and Electronic Frontier Foundation lawsuit in 2006, which they won, to the extent of saying that no, that's not allowed. There has to be judicial oversight. You have to be able to talk to your lawyer. With 2 minutes left.
A judge or whatever, how can they put it in that order?
Because the law, the NSL law that was passed, says they can.
But it was ruled unconstitutional.
But nobody cares about that. They don't. They just do it anyway. Amazing. We think that if it's ruled unconstitutional, then people stop doing it, but they don't. Okay, so at NIST, we are attempting to mitigate what's going on with these national security letters and the SmartGrid. We're really concerned about the disclosure, along with Electronic Frontier Foundation. EFF and ACLU have been filing a number of lawsuits. Here I've included Chris Segoyan's doctoral dissertation that he submitted last week, July of 2012, for those of you who may be interested. This is related solely to telecommunications. My interest is in SmartGrid information, but they're very closely related. This is a summary of the NIST 7628 is the publication that we on the Cybersecurity Working Group published in 2010, in which we call attention to this and a number of other threats as part of the SmartGrid Interoperability Panel. And the future of SmartGrid privacy is depending on the Electronic Frontier Foundation, the ACLU, EPIC, Electronic Privacy Information Center, NIST, our cybersecurity working group that's trying to call attention to this, and you. And that's the end of my presentation.